Hi, this is Chris Fanning with Schantz here again to continue our multi-part video series on the steps of a divorce. So far we've talked about the initial planning session, temporary issues, the discovery phase, and the assets and liabilities spreadsheet. Today we're going to be talking about the mediation and settlement phase. So in mediation and settlement, what we're kind of trying to accomplish here is avoid trial. And we do that by kind of asking two questions. One, what's going to work for everybody? And two, what can you expect a judge to do if you were to go to court? Mediation is favorable because when you're sitting there talking about it with a mediator or between the parties, you're in a little more control, whereas if you go in front of a court, they're going to do the best they have with the information that they have. It's also a lot less expensive and can be a lot more enjoyable than being cross-examined or having to give testimony. Mediation can be court-ordered for issues like custody of children or parenting time, or it can be done with a private mediator. In the last video we talked about assets and liabilities. In private mediation, that asset and liability spreadsheet is very important because that's where you're going to look at all the assets, try to figure out how you can evenly and equitably distribute those assets. You don't necessarily have to go to a mediator. Another way that we approach this is to send settlement letters between the attorneys. It's similar in that you're taking the information that you have, saying this is what we think is fair, this is what we think a judge is going to do, and this is why we should resolve it without going to court. If neither mediation or settlement works, then you'll be learning about that in our next video, which is what happens when you go to court. Thank you so much.